Welcome back to the Law&Crime Network. We are closely following the Gebhardt trial out of Georgia. We just heard before the break closing arguments from the defense. Really a compelling closing argument. The state put on its case to try to close this cold 1983 murder case. The defense really did have a strong comeback. They had a quick defense argument. They rested really quickly, but their closing arguments were compelling, poking reasonable doubt all over the case. With me, we have Jessica Jackson. She's on Skype with us. Hi, Jessica. Thanks for joining us.
Thank you for having me on.
Jessica is the national director of Cut 50 and a defense attorney herself. And we were discussing in the break and going over these closing statements. And I think the defense did a really good job poking holes in the case. I mean, the state came on and discussed how, you know, we have to listen to the witnesses who are already jailhouse inmates, and that they're apologizing for the lack of evidence in the botched investigation. And they're relying on an admission, which we're hearing through other witnesses who are currently in jail for other charges. Then the defense comes on and pokes holes at every single witness that the state brought on, one by one, and says, you have no evidence. You may have a bad guy, you may not have a likable guy, you may have a racist guy, but that doesn't mean he committed murder. In your experience, how do you think the jury is taking this? I mean, we have a guy that we don't like, but did he commit this crime? Can we prove this, or is there reasonable doubt?
Right, and that's normally why we're so careful in the voir dire, right? We have to really put out you know, a lot of the facts early on about the case or the person's personality, and pick out jurors who can be fair and who won't just simply convict somebody because they don't like him or they think he's a racist. So here I think the defense's argument saying that there's a lack of evidence is exactly what they need to be focused on. There is a burden of proof in this country, and the prosecution, in order to get that conviction, has to meet that burden of proof. So with jailhouse informants, who we know are not as reliable, as well as, you know, missing evidence and an inability to show that there really was a crime here, all of that combined, you know, makes a really strong argument for the defense. And if a juror is sitting there knowing that they have to convict this person by actually meeting that burden of proof, they're going to be struggling to do so.
Right, and I think you bring a very important point up about voir dire. When I was a prosecutor, I remember a very critical question that public defenders or defense attorneys would ask the panel. They would say, would you rather convict a not guilty person or let a guilty person walk free? And almost unanimously every time, everyone would raise their hand and say basically that they would rather let a guilty person walk free than put an innocent person behind bars. So who knows how this jury panel is taking the facts of this case. But Jessica, I want to go back to you with one more question here. You know, we're listening to these jailhouse inmates, right? We're relying on them. And some of them, if you've been watching this trial, even the one this morning, the one that was convicted for possession of meth, they seem credible. They seem polite. They seem respectable. They don't seem to have motive. But then you hear the defense attorney come back and say, nope, they have motive. They're going to get a reduced sentence. They can negotiate. Do you think the jurors are taking into consideration and saying that their testimony is not as credible because they're already in jail and now could negotiate a reduced sentence?
You know, I think that's something that the jury will be taking into account. It's very important when you're evaluating credibility, and the jury, you know, not only evaluates the evidence based on what the person says, the witness says, they also evaluate that witness's credibility. And something like receiving a benefit in exchange for testimony is certainly going to make them less credible. We've seen this, you know, this raises a systemic issue of whether or not prosecutors should be allowed to kind of bargain with people who are inside and say, you know, in exchange for testifying against somebody else, we're going to reduce your sentence, because that might actually prompt people to not be honest and to instead, you know, confirm motives and testify in cases when they have their own motive, their own personal agenda, which is their own freedom for doing so.
And what about the fact that there's really no DNA in this case to pin him down as guilty or not guilty? Do you feel like that's critical, or is that something that is extraneous and not necessary because we have enough information?
You know, I think 15, 20 years ago, you probably didn't need DNA evidence, but in the wake of what I would call the CSI effect and so many shows on TV, you know, that folks watch saying, you know, this is how we collect all the evidence, this is the DNA, also compounding, you know, all the exonerations that the Innocence Project and others have been able to get based on DNA after a person's been convicted. I think that it will give the jury some serious pause not to have DNA evidence in this case, even though, you know, obviously it's been so many years since the crime occurred, that it would be very hard to actually have that evidence.
Right. And another thing that I think is going to give the jury some serious pause is the fact that it took 35 years for witnesses to speak up. But before we talk about this further, we're going to go to a quick break. These are the top legal crime stories in the news today.